Thank you, Mr. President. Thank you, Senator Hughes. Are you familiar with a case called I pulled up my wrong document here. Indulge me one moment, please. There we go. Texas Right to Life versus Van Steen. Familiar with that case?
I confess the site sounds familiar, but I'm not familiar with the case. Please, I'll take your word for it. What's it?
It's a 2021 case. There was a ruling by in multi-district litigation, Judge Peoples, conservative Republican, and he ruled on the private enforcement mechanism that is in Senate Bill 8 that you passed a couple, was it last session?
It was 2021, and I do remember that case now. Yes, sir.
Okay, and what is that private enforcement mechanism that was at issue in that case?
Well, in Senate Bill 8 and the heartbeat law, that was a citizen standing, and so just like in our Medicaid fraud statute, it allows any person to bring suit. That's a little different than the standing in this case, but I'm sure we'll get there. So that provides standing to anyone in Senate Bill 8, just like our Medicaid fraud statute.
And we will get to the standing issue. Standing comes from the open courts part of the Texas Constitution, right? That for every person who's done an injury in it's the old his language, lands, good, person, reputation, shall have remedy by due course of law. And that's standing. The general principle of standing in Western jurisprudence is that somebody has to have been injured in order to have standing, correct?
That's correct insofar as the general principle goes. As you know, the state law on standing is very different from the federal law. The U.S. Congress does not have authority to issue standing on just anyone. The Texas legislature does.
In fact, that heartbeat bill, as well as this bill, grants standing to individuals who have not been injured. Is that correct?
That's correct, as the legislature can do.
And as you've observed, that's not unique because we've done that in QTAM provisions involving Medicaid fraud and other things.
Yes, sir.
But there are some things that are different. And in fact, in the context of the amendments from that prior legislation that amended the Health and Safety Code and created sections 171.208, sections A and B, that court, that conservative Republican judge who believes very much in the separation of powers established by the framers of our Constitution, declared that those sections are unconstitutional for three independent reasons. And I want to ask if you're familiar with these. The first was that that the grant of standing to, quote, any person to be awarded, quote, no less than $10,000 and to apply a mandatory injunction without showing harm to that person violates the Texas Constitution's open courts provision and is unconstitutional for lack of standing. That's the first of three independent elements. The second one, the court found that the mandate that trial costs shall be awarded in an amount no less than $10,000 to an unharmed claimant to whom the law granted standing will deprive persons of property without due process of law guaranteed by the 14th Amendment of the United States Constitution. The third and final ground that was ruled in that case found it unconstitutional, that the law delegated executive power to private persons. It's unlawful to delegate that power because it violates the Texas Constitution's separation of powers. Are you familiar with that holding?
I do remember the opinion, yes.
And is that the current state of the law so far as you understand?
I do not believe it is. And Judge Peoples, a long-serving member of the judiciary, I've appeared before him, not related to this bill or the one you're describing. Respected judge.
Good judge.
With deep respect to him and to the court, that case was wrong. He decided that wrong. He got that wrong.
Oh, okay, you think he got it wrong. You know there was an appeal involving whether or not our anti-SLAPP statute applied in the context of that case, or are you familiar with that?
I'm vaguely familiar, yes, sir.
Okay, and there has been subsequent appellate procedures and holdings with respect to anti-SLAPP, but so far to date, the finding of the three independent grounds on which Judge Peoples found Senate Bill 8 unconstitutional have not been reversed.
I don't believe they've been appealed, Senator, because they're moot, because as you know, the U.S. Supreme Court allowed Senate Bill 8 to stand, heard the case, and so I don't believe anyone has appealed Judge Peoples' ruling because they've been mooted. His ruling has been mooted. That's my view. You tell me if I got that wrong.
Well, it actually, one of us is right, and the court, it either has or it has not. But you do understand that he did hold that those were unconstitutional.
Yes, sir.
And some would think that the very same provisions in this bill will be unconstitutional for the very same reasons. So let's get into this bill, go through its provisions rather systematically. And we'll warm up with the easy stuff. Let's warm up with, this is your bill, page 3, lines 15 and 16. This section of the bill has to do with the standard of proof. A person is liable, as paragraph C, a person who engages in conduct described by subsection A, this is the sale of the drugs this bill is aimed at, which are already illegal, is liable for damages resulting from the death or personal injury sustained by an unborn child or pregnant woman if the person's conduct contributed in any way to the death or injury, et cetera, et cetera. Now, the standard in tort law is proximate cause, proximately caused the injury. Does this depart from the traditional standard of proof in tort claims?
Strict liability, Senator. This is strict liability.
Well, strict liability has to do with everybody being liable. It's everybody being liable if they're you tell me about strict liability.
No, thank you, Senator. So the concepts here are borrowed from products liability law. And so in products liability, if XYZ Corp manufactures a dangerous product and they inject that product into the stream of commerce and it makes its way to Texas and you are harmed by it, strict liability under products liability law says they are responsible. It's a much relaxed showing you would have to make to succeed in a lawsuit against them. That's the concept here.
Strictly, absolutely, and jointly and severally liable for, contributes in any way.
Yes, sir.
Okay. Let's take a look at the statute of limitations. Standard statute of limitations in tort law is?
I guess 4 years for breach of contract, 2 years for car wrecks, claims like that. There are other statutes where we'll set them at different levels. Is that what you're talking about?
Yeah, but your bill sets a different statute of limitations, correct?
I beg your pardon?
Your bill sets a different statute of limitations. It departs from the traditional 2 years that we find in the Civil Practice and Remedies Code and common law.
It does. Well, I'm not sure if 2 years is, common law is kind of all over the place. Louisiana has 1 year.
Civil Practice and Remedies Code in Texas?
Right, so that's the statutory rule. That's right, 2 years for most torts.
Okay.
4 years for breach of contract. I'm not sure if we're talking about the same thing.
Your bill has 6 years.
Yes, sir.
Very good. That's unusual. Is it unusual?
There are not a whole lot of 6-year statutes of limitations in Texas code. That's correct.
I'm not aware of any. Let's move on to jurisdiction. No, actually, let's not. This statute creates a cause of action, a key TAM cause of action, not only a person against who may have violated the section, but against anybody who intends to violate. So this is private citizens can bring a lawsuit on the theory that somebody intends to violate the law. Do we have examples elsewhere in Texas law where we give someone standing to sue someone because we think they intend to violate the law?
Well, sir, to the intent we're describing here, if these pills, these dangerous pills, are mailed into Texas, whether those pills successfully harm a little baby or a mom, the act of shipping those pills with that intent is sufficient to trigger liability under this law.
You ever see a movie called The Minority Report? I think it was Tom Cruise.
I think I did.
And I think they had advanced into a dystopian state where they are arresting people who were thinking about committing a crime.
I'm not sure if I saw the whole thing. It was probably on TV, but I'll take your word. That sounds familiar.
Just wondered if you've seen the movie.
There was something with his eyeball, right? Is that the movie where he switched his eyeball to
The whole
somebody
eyeballs
else?
thing was there,
Okay.
that's for sure. Yeah,
Okay,
that's
thank
why we both remember it. It just, that statute section reminds me of it. Page 8, protection from counteractions. Is this designed to do combat with other states who have shield laws?
Yes.
Kind of pits Texas against every other state who might have these laws, so that if somebody is practicing medicine or manufacturing, in this case manufacturing drugs, and selling them in accordance with the law of their domicile, this sort of purports to preempt the law of other jurisdictions, correct?
Tells them they shouldn't mess with Texas. Yes, sir.
Okay, so we'll have questions about whether or not that's valid in the courts. I mean, you and I don't need to do it because neither you nor I has the power to rule on it. In fact, we'll learn later on that it appears the courts don't have the power to rule on this. But that's the climax. We don't want to get there yet. This, I think, will be less controversial, though we haven't really gotten to much fireworks yet. Also on page 8, section 171A.351, there's an explicit reference to what I call chapter 6.5, and it's called chapter 6.5, title 71. In Senate Bill 31, there were express references to the intention of that bill. In fact, that bill cannot be construed to have any effect on the current legal status of any prior decision, specifically the 1925 law. It's not your intention through this paragraph to affect the legal status of that law. Is that correct?
Well, Senator, no, that's an important distinction. As you'll recall, in 2021 in Senate Bill 8, the legislature made a finding that that statute is alive and well. Subject only to the...
Some of us made a finding, but your bill made a finding.
Well said. And so, passed by the legislature, signed by the governor. And so that was in 2021, and that's in front of the Fifth Circuit as we speak. And so this bill, 2880, not Senate Bill 31, but 2880, makes a finding consistent with Senate Bill 8.
But there's a finding?
Well,
we're not finding that bill is alive by virtue of this paragraph, are we?
Senator, I was imprecise. You're right. It's not a legislative finding, but it does state that statute applies here.
Do you think, or do you intend, that this sentence on lines 8-50 through 8-53 on page 8 of Senate Bill 2880, committee substitute to Senate Bill 2880, do you intend for it to have any legal weight in a judicial determination as to whether or not the 1925 law is currently in effect?
Senator, in 2021, the legislature, the majority of the legislature, in a bill passed by both houses, signed by the governor, found that statute is still around. This... I'm sorry, go ahead. I was going to say that this should help provide guidance to courts that, yes, we mean that statute as well.
Okay, interesting. Personally, and as my own legal opinion, is that the legislature doesn't have the power to declare that a law that a court has ruled has been impliedly repealed, in fact wasn't. And you would disagree, that's why it's in your bill, and that's something the Fifth Circuit's going to take up.
That's exactly right. That's sometimes referred to as the writ of erasure fallacy, the belief that a court by fiat can strike a law from the books. Of course, that's not literally or legally possible.
Or the Latin phrase for the fallacy of the legislature believing it can declare what happened or didn't happen with the law when courts have the province of making those decisions. But that's something the Fifth Circuit will handle because they've got better grades than you or I did in law school.
Yes, sir. I used all my Latin on the last bill, so I'll defer to you. I'm not sure.
But I think it's very important that we make crystal clear what you just said, and it surprises me a little bit that you do in fact intend this paragraph to say to courts that this legislature believes that the 1925 law is current and good law, because that's precisely what you ensured would not be said in Senate Bill 31.
Senator, in Senate Bill 31, as you'll recall, that language says, by this bill, the legislature expresses no opinion.
Correct.
We didn't say it was or it wasn't. In 2021, we specifically said it is.
That's right.
That's right.
In this bill, Are you expressing an opinion, or are you expressing no opinion as you expressed no opinion in Senate Bill 31?
This bill is telling a court when we refer to abortion laws, we are including that statute.
So it's expressing an opinion.
Yes.
Would you be amenable to an amendment saying you're not expressing an opinion, so this would mirror what we did in Senate Bill 31?
Senator, I wouldn't. Of course, obviously, I'm just one vote. But for purposes of this bill, this is not Senate Bill 31.
Okay. Well, that's disturbing. Moving on. Fee shifting. The very next section, section 171A.353, awards, which is not unusual, that the prevailing party can get attorney's fees, right? We do that all the time.
Yes.
There are a couple things that are a little different, though. Notwithstanding any other law, a person, including an entity, attorney, or law firm, et cetera, et cetera, et cetera, who takes up the cause of representing somebody who challenges this statute is deemed to be one of the people who's liable for fees. A lawyer who takes a client is liable for the other party's fees. That's unusual, isn't it?
Well, Senator, fee shifting does not have to be mutual, does not have to be mirrored in a statute. As you know, you mentioned the
yes,
you mentioned
weird.
You mentioned the TCPA earlier. That has situations where attorney's fee shifting goes one way but not the other. But to answer your question, yes, that's what this does.
But the TCPA does not make attorneys who represent clients liable when they lose the case, right?
I know I brought it up. I'm not sure. I know it does have different fee shifting measures. I'll defer to you on that.
As a practitioner, would you think that it would have a chilling effect on people's ability to hire counsel if counsel is going to be liable for the other party's fees if they lose the case?
Well, Senator, this is the legislature expressing its will on a matter of high importance.
And is that a yes?
And expressing state policy.
It was a yes or no question.
What was the question?
The question was, do you think it would chill the ability of an individual to retain counsel if lawyers know that if they lose the case, they're going to be liable for the other side's fees?
Senator, in matters like this, the chair says loser pays. That's right.
I'm taking that as a yes. And that's the point, isn't it? The point is to discourage people from challenging this law, isn't it? The point of this provision is to discourage anybody from daring to challenge this law.
Fee shifting provisions are used by the legislature to discourage or encourage conduct all the time. That's right.
Now, what does it mean to be a prevailing party under this statute? It says it in the next section. For purposes of this section, a party is considered to be the prevailing party if a state or federal court dismisses the claim, et cetera, et cetera, et cetera, right?
And then it says, to the extent that those costs and attorney's fees were incurred while defending claims or causes of action on which the party prevailed. But go ahead, I didn't mean to interrupt. I'm on line 25, 9-25.
Yeah, and I think I'm going to move ahead because my own brain is getting tired on that phrase, and there's so much else to pick on. Why harp on that? Normally, if a lawyer tries a case, they can move for attorney's fees, and they're either statutorily awarded, or they're contractually awarded, or they're discretionarily awarded. But if the lawyer messes up and forgets to ask for attorney's fees, and the judge's ruling becomes final, and it did not include an award of attorney's fees because the lawyer screwed up and didn't ask for them, it's game over for the lawyer, right? They don't get to go back and get fees later, correct? Not under this statute, but generally in law in your experience as a professional.
Senator, I think it depends on the statutory provision, but I believe that's the general rule. I agree with you.
Thank you. But in this bill, I found this remarkable. There's paragraph D that says, regardless of whether the prevailing party sought to recover costs or attorney's fees, i.e. regardless of whether they forgot to ask and a judgment came down, you can file a new lawsuit up to 3 years later and come back and ask for those fees. Am I understanding this paragraph correctly?
That's right. That's right.
Have you ever seen that in any other law in Texas jurisprudence?
Senator, I have seen cases where a settlement agreement, for example, lawyers settle a case and there's a letter agreement that says we're going to pay this on this date. And when the settlement, there's already a lawsuit pending and we settle the case and we sign a letter.
Right.
Rule 11 agreement. I have seen litigation brought to enforce those after the fact within the statute of limitations because it's a breach of contract, if that's the kind of concept we're talking about.
But this isn't about a breach of contract, is it? And it's not a settlement agreement, is it? It's somebody who brings a claim under the law as you've drafted it here. They get 2 tries to get attorney's fees.
That's right.
Really, really, really encouraging one side to get their fees and making it impossible for the other side to get their fees.
It's a strong statement of policy by the legislature if the bill passes.
Here is the next paragraph. It's not a defense to a civil action brought under this subsection that the prevailing party sought to recover their fees, that the court declined to recognize or enforce this section. The court could have refused to enforce this section and they didn't get their fees, and later on, within 3 years, you could still bring a suit to get your fees anyways. Are we going back to the trough too many times here?
Senator, the intent is to be a very strong and unequivocal statement to those who would ship these pills into Texas that don't do that. Unless we're talking about the life of the mother, of course, which this type of abortion treatment, we've not seen that indicated in a situation like that. This is a strong statement about these pills and their harm to little babies and to women.
And you'll notice
right. It's strong.
And you'll notice nothing in my questions has anything to do with abortion. I'm dealing with jurisprudence.
We're talking about the strength of the remedy here, but yes, sir.
Yep. And the last of those 3 things that you can come back and get your fees 3 years after the fact is if the court that you were in the last time found this law unconstitutional.
Yes.
Wow. Okay. Now, this part starts to sound kind of good. I liked it when I first saw it. Now I'm on page 10. I'm at section 171A 403, construction of chapter related to asserted defense. This chapter may not be construed to prevent a litigant, even a defendant, from asserting the invalidity or unconstitutionality of a provision or application of this chapter as a defense to an action, claim, or counterclaim. Yay, defendants still have their constitutional rights, right?
This makes it clear that there's nothing in this bill that takes away your constitutional right to bring claims, to seek redress. That's the point of that. You're right.
But this reminds me of something that my 3-year-old once said when we had something declared that's great. He said, "There's just one problem, Daddy." And here's the problem. The problem is that no court can rule that anyone has the Constitution, that no court can find this unconstitutional.
Senator, if you're talking about a pre-enforcement challenge, that's very different. But let me say, okay, well, go ahead. I want to make. Let me finish. As Senator West would say, the way this bill works, not unlike the heartbeat law, when a claim is brought against a civil claim under this bill, of course that person can raise constitutional defenses and whatever defenses they wish. And they can remove a case based on the laws. If they prefer federal court to state court. All those are in place. But if you're talking about a pre-enforcement challenge, that is affected by some of these provisions, not unlike how Senate Bill 8 did.
And I know there's stuff about Rule 202, and just because there's so much to cover, I wasn't going to get into that. But I'm not actually talking about pre-enforcement challenge. At least I don't think I am. I'm talking about the very next section, section 405, dealing with jurisdiction. It says, a court of this state does not have jurisdiction to consider and may not award relief under any action, claim, or counterclaim that seeks declaratory injunctive relief or any type of writ, et cetera, that would pronounce any provision or application of this chapter invalid or unconstitutional. So on the one hand, the previous paragraph says you have a right to defend yourself based on your constitutional rights. The very next paragraph says no court has jurisdiction to find this law unconstitutional.
No court of this state. It means you go to federal court.
Oh, okay, you could go to federal court. So,
of course.
So we're minimizing the damage here, or at least reducing it. You're not purporting with state law to preempt a federal court's right to review this bill for constitutionality.
Definitely not.
You are, however, and this is of profound legal significance, declaring that the judicial branch of government does not have the power to review the law we pass for constitutionality. Am I reading this bill correctly?
Senator, just like the Congress under the U.S. Constitution.
But please,
just
Senator,
like
just yes or no first.
Just like the Congress under the U.S. Constitution.
And the whole paragraph.
Can determine the jurisdiction of the courts, so can the legislature set the jurisdiction of the state courts.
And can it do this? Can it tell the courts you can't review a law for constitutionality? Or is this a flagrant, brazen transgression of the principle of separation of powers on which this country and state was founded?
No, sir. We make the rules, we set the jurisdiction.
So I suppose on every single law we pass from now on, we could put a provision in there prohibiting any state court from reviewing what we do for constitutionality. Everything we do.
We could if we wanted to, knowing those claims would then have to be brought in federal court, and we'd have to make it, the legislature would have to make a decision, all of us, as to whether that was good policy on a given bill.
And I suppose judges at that point would issue marriage licenses, and I don't know what they would do, but they certainly wouldn't be looking over our shoulder, I guess. It just seems to me that we're holding the judicial branch of government in contempt if we're going to tell them they can't review our work. And I'm surprised that you're not equally troubled by this.
Well, Senator, I want to stress the language on 1058 would restrain a person, including this state, a political subdivision of the state, or an officer, employee, or agent of the state, from enforcing any provision, filing, hearing, adjudicating.
I really want to follow you. Tell me where you are.
No, I'm sorry. I'm still on page 10, line 59, 58 through 60.
Okay.
Again, the context is a pre-enforcement challenge. But in any case, federal court is always there, and there's no attempt to limit their jurisdiction.
Okay, let's keep going then. The next paragraph, effect of contrary judicial actions, right on the same theme here. If a judge dares to find this law unconstitutional, this paragraph says, notwithstanding any other law, judicial relief issued by a court of this state that disregards the immunity conferred by Section 141 or the limits on jurisdictional or permissible relief described in 171A.405 is considered void because a court without jurisdiction issued the relief. And it may not be enforced or obeyed by any officer, employee, agent, including judicial officer of this state or political subdivision of this state. What does that mean?
Senator, the courts, not often, but the courts do disregard, ignore certain provisions, selectively enforce. For example, severability clauses that are placed in our statutes and that exist in the Code Construction Act. Courts sometimes ignore severability clauses and choose to enjoin an entire statute, not only the offending parts. And so if a court does not follow the law, this says what happens. This is to make sure the courts follow this law.
If they, and I understand if they're selectively enforcing provisions and ignoring severability clauses, that would be fine. If they find the entire thing unconstitutional, does this statute say that their ruling is void?
If they disregard the immunity conferred by 171A.401.
And what is that
yes.
immunity?
171A.401. That was up above where we were reading earlier. Immunity and limits on state court jurisdiction. It starts at the bottom of page 9, starting on line 66.
Okay. Continuing now. We're on page 11. Section 171A.407, liability for violation. A person may bring an action against an officer, employee, or agent, including a judicial official, and that would include a judge, correct?
Yes.
Okay, so these are the people who are given this private right of enforcement. Could be any person in the state of Texas, right?
Let me make sure. Person may bring an action against an officer, employee, or agent of this state, including judicial, of this state or a political subdivision. So this is about government officers, not about private individuals.
Right. But it's a private enforcer that could bring this action against government officers, right?
The one bringing the action, or the one against whom it...
The one bringing the action could be anybody.
Yes, so that's correct. That's correct.
Would be a judge, right? So if somebody,
a judge wouldn't be bringing the action. That would.
Right. So somebody who brings an action under this chapter could sue a judge, and any judicial officer who issues or obeys a writ, injunction, or declaratory judgment, if the writ or injunction or judgment prevents or delays the person from bringing an action under this section, boy, we're getting trouble following all this stuff. Somebody can bring an action against a judge. That's what this says. A person could bring an action against a judge, essentially for finding this law unconstitutional.
Senator, it's only with regard to an order under 171.406B.
Yes.
So it's not the entire act, but it's that portion of it. You're correct.
Right. Okay. Let's look at that section then. Notwithstanding under the law, a writ, injunction, et cetera, that purports to restrain a person, including the state, et cetera, from hearing, adjudicating, docketing, or filing an action brought under this section is considered void and a violation of the Due Process Clause, some irony there, of the 14th Amendment of the United States, and may not be enforced or obeyed by any officer, et cetera. And so somebody who sues a judge for that, seeking declaratory judgment, they get damages against a judge statutorily prescribed here of not less than $100,000. Is that correct?
If a judge were to issue an order preventing you from filing a claim under this statute, yes.
And if the judge issued that order because the judge found the statute to be unconstitutional, somebody could then sue the judge and get $100,000 damages because of that. Is that correct?
A state judge in Texas would follow the law and would not issue such an order because he has no jurisdiction.
Because we said he doesn't.
That's exactly right.
Are you wearing boots, Senator?
I am.
Do they have straps?
I don't think so, no.
Because it sounds like bootstrapping to me. The other funny thing about this is if there is a judge who is having to defend herself or himself under this provision, they may not receive or obtain legal representation from the Attorney General. Now, that's not very nice, is it?
Ignoring the law is not very nice. When the legislature specifically sets it out in a way that's clear and unequivocal.
Are you familiar with the principle of judicial immunity?
I am.
And does this statute waive judicial immunity in this instance?
For an act under this section, I don't see a specific waiver of judicial immunity, but it would have the effect of holding a judge accountable for violating the law in that setting.
I appreciate you correcting me. I used the word waive. It doesn't say waive. It says that a judge may not assert and is not entitled to any type of immunity defense.
That's right.
Or judicial immunity. Are you aware of any other instance in which judges will be personally liable for a monetary payment to a claimant, particularly one who doesn't have standing? Nope, shouldn't have said that because under this bill they do have standing, I guess.
The example
do judges ever get held liable for not ruling the way the legislature says they should?
The example that comes to mind would be the Michael Morton Act, where a judge, former prosecutor, I believe was held to criminal offense for activities that would normally be considered immune because they had to do with prosecution of a case. But they were so egregious and so harmful that the judge was held criminally liable. It's the only case I know of in Texas, happened up the road, and I don't know the judge, I just read about it. But that's one that comes to mind. And you may know of others, but that just comes to mind.
I don't. That's my point, and I appreciate you coming up with the criminal example because that's a criminal case and this is civil, and it's understandable that we're going to hold the judge responsible and accountable for criminal violations. But this is civil, and I don't know how will judges do their job if we expand this principle to all sorts of things when we think the judges aren't following the law the way we tell them to.
Well, Senator, as far as civil versus criminal, I don't want to split hairs, but most folk would probably consider criminal liability a lot more serious than civil liability. But to answer your question, with every bill we pass, we make these choices. And if the conduct is serious enough, then we use methods like this.
If we did expand this, do you think it would make it difficult for us to recruit judges? If we expanded this to all kinds of other areas, if we had other laws that said any judge who finds what the Texas Senate and the Texas House and the governor's signature did, any judge that dares to find that unconstitutional is going to be liable to somebody for a bunch of money. Isn't it going to be difficult to persuade any judges to exercise their constitutional obligation to review our work?
It's a remedy we should not use lightly.
I appreciate that. I think I'm near the end here. We're now in section 171.2105, and that is on page 12. A court of this state does not have jurisdiction to consider and may not award relief under any action, claim, or counterclaim that seeks declaratory or injunctive relief that would pronounce any provision or application of this subchapter invalid or unconstitutional. And so there we have it, clear as a sunny day. The courts don't have jurisdiction to consider whether or not this law is constitutional.
State courts do not, that's correct.
Thank you, Senator Hughes.
Oh, thank you, Senator.